Hello, everybody. Welcome back to SEC Roundup. I'm Tom Zuccaro, a partner with Paul Hastings in Los Angeles and a member of the Investigations and White Collar Defense Group. With me, as always, is my partner, Nick Morgan, also a partner in Los Angeles with the White Collar Defense Group. Hello, Nick.
Hey, Tom. Hey.
And we're delighted to have join us today Peggy Little, who's a senior litigation counsel with the new Civil Liberties Alliance in Washington, D.C. Peggy, welcome.
Thank you. Thank you for having me.
So we're going to talk about the SEC's administrative process in this episode. The process and administrative proceedings have taken a lot of criticism in the last few years and some constitutional challenges. One of them was by Michelle Cochran, an accountant in Texas, who challenged the constitutionality of the hearings under the Supreme Court's guidance in the Lucia case. Nick, why don't you give us a little background on what her case has been like and the litigations he's had in federal court in Texas?
Yeah, poor Ms. Cochran's situation is sadly not unusual. So she was a CPA at an auditing firm in Texas. The SEC investigated one of their audit clients, brought a case against her and other members of her firm in an administrative proceeding. This is back in 2016, to give you some idea of how long these things go on. The administrative law judge, or ALJ, issued an order against her, imposing a penalty. And their thing sat. That was in 2017. And then unrelated to that action, at the same time, there was someone else, the person you mentioned, Ray Lucia, who was challenging the constitutionality of the administrative process. And after the administrative law judge had issued the order against Ms. Cochran, the Supreme Court ruled that the ALJs were unconstitutionally appointed. So that you would think that would be a good thing for Ms. Cochran, and ultimately, hopefully it is, but that's where things get strange. And I think, Peggy, you should probably take the story up from there, because that's where the constitutional issues that are currently being discussed come up.
And Peggy, you represent Ms. Cochran, right?
Yes, New Civil Liberties Alliance represents Michelle Cochran. We also represented Ray Lucia on remand. And in both of those cases, after the Supreme Court decision had come down, we sued in federal district court because the administrative law judges still had multiple layers of removal protections, which made them unconstitutional under Article 3 and under a 2010 Supreme Court case called Free Enterprise Fund. And in both of those cases, we said they have to be able to go to a real Article 3 court and have this issue decided. What made it a difficult task for Ray in San Diego and for Michelle in the Northern District of Texas is that there were 5 circuit court cases that had held that no, you have to go through the administrative process first, and then you get a right of review at the circuit courts. And we said that's insane because
it is insane.
The whole point of the removal challenge is that the administrative law judge can't decide anything, much less their own qualifications to sit. And that's logical. That would be obvious to any layman. It apparently is not obvious to a lot of courts. And so we had this tremendous hurdle of 5 circuits going against us on this issue. But we were determined to prevail, and we filed suit in San Diego and in the Northern District of Texas. Poor Ray Lucia, who had been impoverished by this entire process, going all the way up to the Supreme Court and winning on the appointments issue, saw another 6 years of litigation ahead of him, and so he had to throw in the towel. He was completely depleted in every way. His reputation, ruined for life. So Michelle was feisty, was willing to carry on the fight, and she did. We went first to the Fifth Circuit. Well, we had a little bit of a boost from our district judge. He followed those 5 circuits, but he said he was in fact deeply troubled by the fact that she would have to go through this proceeding, and then before she could ever get before a court competent to decide this question, and then she would have to go through it all over again. When I first started this work, someone once said to me, "You will find yourself using the term Kafkaesque a lot." Yeah. And this is, if you want to go ancient Greece, this is Sisyphean. It's pushing that rock up the hill, and then you win, and the prize you win is you get to do it all over again. And we can laugh about it, but for the respondents involved, it's madness. These things go on for years, and they are not before a court competent to decide whether the administrative law judge is constitutionally able to sit on their case. So in Michelle's case, we went before a panel, and the panel held against us, but we got a dissent. And that was the Second Circuit dissent at that point. Judge Haynes dissented in the Fifth Circuit, and one of the 5 circuits against us was the Second Circuit, and there Judge Droney had dissented and written a powerful dissent. So with those 2 dissents in hand, we moved for en banc reconsideration, and we got it. I argued that during the time of COVID, so I had 16 small faces on the screen in a circuit I had only practiced in for a short period of time. So that was an adventure.
Challenging.
Well, it was a fun argument, actually. I enjoyed it a lot. And the judges seemed very engaged and very willing to rethink these things. It's very easy to say, well, 5 circuits have decided, but as the district judge here noted, there's something terribly wrong. No system of justice would ever be designed in the fashion where if you want to challenge the administrative law judge's authority to rule in your case, you have to let them rule in your case first, and then you go to another court to figure out whether they should have done it in the first place. It always bothered me a lot that those circuit judges didn't seem to get a proper proposition that was that simple. And as this process was going on, there, for example, in the Drug Enforcement Administration, there was an ALJ who actually ruled, I can't rule on my own qualifications. So, it was even getting it to be obvious to the ALJs that something had gone wrong here. So we prevailed on the en banc.
So
we hope so. This is what had happened in the meantime is in the Ninth Circuit, there's a case called Axon, and they have the same problem with the FTC judges. And so they had brought a challenge very similar to what we did for Ray and for Michelle. And NCLA, where I work, actually filed an amicus for them at the district court, and we also filed an amicus for them at the Ninth Circuit. They also pulled a good dissent, and then they petitioned for cert. What happened in the meantime is the victory in Cochran came down and created a circuit split. So Axon goes up, and then the SEC decides, in our case, to file what's called a hold petition. They have asked this Supreme Court, they filed for cert because they certainly did not like losing at the Fifth Circuit, but they asked the Supreme Court to hold pending the decision under the FTC statute. We have filed a response that said, no, we want plenary review, and there's good reasons for that.
Well, we'll wrap up the episode here. Peggy, thank you so much for all of your insights. We really appreciate it. Nick, great to see you as always. And we look forward to seeing everyone back for our next SEC Roundup episode. Thank you.